William H. Rehnquist is the Chief Justice of the nation's highest court. All the Laws But One is his latest book on Supreme Court history. It analyzes the balance between government interests and civil liberties during wartime. We went to the Supreme Court building in Washington, D.C. to talk with Justice Rehnquist about his book.
Chief Justice William Rehnquist, where did you get the name for your book, All the Laws But One?
I got it out of Lincoln's address to Congress in July of 1861.
What does it mean?
Well, what he said, let me have page 38 there, if you will.
Okay.
I can give you the exact
I'll find it right here.
quote.
And let me just ask you while I'm finding it, why did you decide to do this? What got your attention on this whole issue?
The whole subject of civil liberties in wartime. I read David Donald's biography of Lincoln that came, and that didn't devote a great deal of attention to it, but it got me kind of interested again in Lincoln as a person and his conduct during the Civil War. And so that's what got me started. At first I thought it would be just a book about civil liberties in the Civil War, but then it turned out that didn't seem to have quite enough material for an entire book, and I got interested in carrying it forward into World War I, World War II. Yeah, what Lincoln said was, he said if Roger Taney's judgment that he had no authority by himself to suspend the writ of habeas corpus in Baltimore should be given effect, you would be letting all the laws but one go unexecuted, and the government itself go to pieces, lest that one be violated. And that's, he just phrased beautifully the classical confrontation between the needs of a government at war and the civil liberties of the citizens.
What is a civil liberty?
A civil liberty, I think, is a right that a citizen has against the government. Like, you know, you have a right to be tried by a jury, and you have a right not to be, have your free speech abridged.
What's the writ of habeas corpus?
The writ of habeas corpus is a traditional common law writ that was embodied in one of the, either the Petition of Right or the Bill of Rights in England in the 17th century. And it's a writ if you're detained by the executive, the police or anything like that, you have a right to ask a court to have your custodian bring you into court and give the reason why you're being detained. And if the court says that's okay, then the writ is dismissed. But if the court says that's not a sufficient basis for detaining you, then the court will free you.
You are often mentioned when this subject comes up of the writ of habeas corpus, even as a Chief Justice. Is it an issue that you've been looking at for a long time?
Well, there are two quite different applications of habeas corpus. One is this common law writ. And in common law, it was always a sufficient defense on the part of the executive if they simply said, you're being held for trial, or even more sufficient if the executive said, he's already been tried and convicted of something and been sentenced to 20 years. But beginning maybe half a century ago, the congressional statute providing for federal court review of state judgments where the person was being held in violation of their rights was held to allow a review by federal habeas corpus even after a state judgment of conviction had become final. If you're charged with murder in a state court, the jury finds you guilty, the judge sentences you to life in prison. It goes all the way through the state court system. Now, a century ago, that would have been the end of it. But today, under this federal statute, you can still go into federal court and say that some federal right of yours was violated, and that's called federal habeas corpus. But it's a greatly expanded thing from what the common law writ was.
I know you deal with this a lot, but for the generalists out there, what is a writ? Define the word.
A writ is simply kind of an order that issues out of a court.
In the early part of your book, you give credit, and well, first of all, you dedicate the book to Nancy, and then you give credit right out of in the acknowledgments to your daughter, Nancy, is it Spears?
Yes, that's who the book is dedicated to, too.
But you also say that she, I'm looking for the actual language here, that she made you sound less like a lawyer. And how did she get it? Where is Nancy Spears? Where's
She's in Middlebury, Vermont. She has a writer in her own right, and she's married to her husband, Tim, who's a professor of American Studies at Middlebury College. And she said she felt that was one of her tasks, was to make me sound less like a lawyer. And Pat Haas, my editor for Knopf, went her one better, and even after Nancy was through, Pat decided she should perhaps make it sound even less like a lawyer. So between them, they've really, you know, they also, the book would be a number of pages longer had it not been for the editing.
When did you read David Herbert Donald's Lincoln?
I was right at the time of my back operation, the fall of 1995.
Had you written or read much about Abraham Lincoln up to that point?
Yes, I'd read a one-volume biography of him and read historical studies of the times in which he lived, Alan Nevin's books.
I would, after I read your book, I was going to suggest a subtitle, you know, All the Laws But One, or The Life of Abraham Lincoln. And there's a, did you enjoy writing all this about Abraham Lincoln?
Oh, I certainly did, yes. You know, you certainly go on to other people in the latter part of the book, but he just stands out in American history, partly because of the difficult times he lived in, partly for his ability to make decisions and factor in political considerations, and partly just for his use of the English language. I mean, he was just unparalleled among, I think, our presidents as in his ability to use the language. And he'd never even been to grade school.
What else did you read besides Professor Donald's book?
Well, there are a lot of books in the bibliography. There are a number of books treating civil liberties during the Civil War.
But about Abraham, for instance, I know you read Nicolay and Hayes' History of Lincoln.
I certainly didn't read every bit of that because it's a number of volumes. I dipped into it, as one might say. And there's a one-volume biography of Lincoln. I can't remember who it's by. It seems to me that's considered the best one-volume biography of Lincoln.
What do you think of what Abraham Lincoln did with the writ of habeas corpus during the war?
I think if I'd been president, I would have done exactly the same thing.
Where did it start with him? When was the first time we heard about him dealing with the issue?
Well, when he called for 75,000 volunteers to put down the rebellion, as he called it, after the Confederate forces in Charleston had fired on Fort Sumter and caused Fort Sumter to surrender. But the troops he called for, he wanted to come to defend Washington, because as a result of the firing of the Lincoln's call for volunteers, before then, just the 7 states of the Deep South had seceded: South Carolina, Georgia, Florida, Alabama, Mississippi, Louisiana, and Texas. But when Lincoln said he was going to use force to put down the rebellion, Virginia, North Carolina, Tennessee, and Arkansas seceded, so that Washington went from being an interior capital of the Union to a capital right on the border of the Union. Right across the Potomac River was Confederate territory. So he wanted the troops to get to Washington as fast as they could, because he feared a Confederate raid, and if you invest Washington or capture the city, you may get British and French recognition of the Confederacy. So the troops coming were very important to him. This is made clear from John Hay's diaries and several other sources. But the problem was that every railroad coming into Washington from the north had to go through Baltimore. And you not only had to go through Baltimore if you were coming from Philadelphia or New York or Boston, the big population centers where the troops were coming from, you had to change stations there. And Baltimore was a hotbed of secessionist sympathizers. It was just a very unruly city. It was known as Mob City. And so The second time a shipment of Union troops came through Baltimore from the north, there was a riot in the city. The troops were marching from one station to another. The crowd pelted them with stones. The troops fired back. 2 or 3 soldiers were killed. Several in the crowd were killed. And it was just a very difficult situation. And that night, the mayor of Baltimore, who was a secessionist sympathizer, and the chief of police organized a group of people, and they went out and burned the railroad bridges leading into Baltimore from the north, so that the troops had to go around by Chesapeake Bay over to Ann Arbor, not Ann Arbor, Annapolis, and to come by a land route, which was much more difficult. And at this point, Lincoln authorized Winfield Scott, who was the commanding chief, to suspend the writ of habeas corpus at any point along the railroad line from Philadelphia to Washington. And Scott proceeded to do so. And he arrested a fellow named Merriman, who was a Baltimore aristocrat who was thought to have been involved in the blowing up of the railroad bridges. And Merriman sued out a writ of habeas corpus before Roger Taney, who was the Chief Justice of the Supreme Court. And Taney issued a ruling saying that the president alone didn't have the authority to suspend the writ of habeas corpus under the Constitution. Only Congress could do it.
Now, in those days, that would be April of 1861.
Right.
Where was the court?
The court was sitting in the Capitol building.
So it's on the other side.
It's on the other side of the street.
And how many members were there of Roger Taney's court?
There were 9.
How old was he then?
Roger Taney died in 1864 at the age of 88, so he would have been 84, 85 at this time. And a couple members of his court had also died in late 1860 or early 1861. I think there were only 7 active justices at the time he was sitting in Baltimore as a circuit judge.
One of the things I noticed in your book is that you seem to enjoy characterizing some of the justices. The one I wrote down was that, you know, talked a lot about their lives, little mini biographies. Felix Frankfurter, you call him a brightly plumaged bird who never gave up his professional mane in his battle for judicial restraint. Where did you get that characterization?
Well, as a law clerk here at the court for Justice Jackson in 1952, I knew him and was fond of him, and he enjoyed talking to other people's law clerks as well as his own, just because he was the eternal professor. And I remember one of his colleagues telling me that, and this was much after my time as a law clerk, that his discussions at conference always took 50 minutes because that was the amount of time he would have spent on a class lecturing it.
Now, that language, a brightly plumaged bird, is that something you enjoyed doing? And when you wrote this book, of using language?
Well, I thought that was an apt description of him. You know, I don't know that I want to be terribly florid all the time.
But when you look at Abraham Lincoln's writing, does that encourage you to want to write like he did, or is that something that just comes naturally?
I would like to be able to write like Lincoln did, and perhaps to think like Lincoln did, because, you know, there's a very debatable constitutional issue behind this whole business of the writ of suspending habeas corpus, and it's because the power to suspend the writ of habeas corpus, or the implied power to spend it, is contained in Article 1, which deals with the authority of Congress. And Taney reasoned that because it was there, it took Congress and not just the president to suspend the writ, which is a perfectly plausible contention. But Lincoln didn't deal with that at all in his message to Congress. He just put it in very understandable terms. Are we going to have the whole country go to pieces because we have to enforce this one law and have all the other laws be unexecuted?
So what happened back there in the confrontation between Chief Justice Taney and Abraham Lincoln?
Well, Taney sent a copy of his opinion to Lincoln. Lincoln ignored it, and particularly after Congress in that summer session, in effect, ratified what he'd done, he proceeded to detain and hold people who he thought were, and this was not so much Lincoln individually, but Secretary Seward at first, who was his Secretary of State, and then when Edwin Stanton became his Secretary of War in 1862, Stanton did it. People they thought were interfering with the Union war effort.
What if an executive did that on other kind of decisions of the court? What would happen to the country?
You mean if an executive defied a decision of the court?
And has it happened very much in history?
I don't think any executive has ever defied a decision of the Supreme Court, though it's apocryphally said that in a case called Worcester versus Georgia that was decided in 1830, when the Supreme Court held that the state of Georgia didn't have any authority over the Cherokee reservation down there. And it was reported later that although the Supreme Court had said this, the state of Georgia just continued to do it. And someone went to Andrew Jackson, who was president, and said to Jackson, you should carry out this decision because you have troops at your command. And Jackson's response was, John Marshall made the decision, let him enforce it, which of course is a rather, I don't know how to describe the comment. It shows very little sympathy for the limitations on the power of a court.
Now this book is your third book.
Yes, it is.
The last book, Grand Inquest, William H. Rehnquist, The Historic Impeachments of Justice Samuel Chase and President Andrew Johnson, I have here, is a book that all of a sudden everybody went to find right now.
That's what I understand.
Did that surprise you?
Well, I suppose given the current political context, it shouldn't have surprised me.
But when you wrote the book, and I know you try to stay away from current cases in front of the court to talk about it, did you ever think that you'd be in a position?
No, it seemed to me as totally historical a topic as one could write about.
Let me ask, I brought an article along that was in yesterday's paper, and I want to ask you about the process of this, not the subject itself, and see, and maybe you...
Yeah, I don't really want to get into any questions about impeachment.
But let me see if you can answer this part of it, because this is an article written by Betsy McCoy Ross in New York. And here's the process part of it. For somebody who would pick this up, she says, because of your book, she says, and even if, let me just make sure, it says, will President Clinton be removed from office? No. Why not? Because Senator Orrin Hatch, chairman of the Senate Judiciary Committee, says that there are not enough votes. And even if the vote were closer, this is what I want to ask you. The man who will play the second most important role in the coming drama, Chief Justice William Rehnquist, is philosophically opposed to impeaching a president for anything except the most serious crimes against the nation. What I want to ask you is that it's fair to deduce from your book that particular paragraph is true.
No, that's a question I don't want to answer.
Okay. Now, why don't you, just for the audience that says he's being difficult?
Well, just let them feel I'm difficult.
Back to this book, then. What else did you write about in the book besides Abraham Lincoln and the writ of habeas corpus during the Civil War?
Well, you mean what else during the Civil War?
No, what else, other presidents? I know you dealt with World War I, World War II.
Yes, World War I, Woodrow Wilson, the Espionage Act, and some of the cases that the Supreme Court decided. Really, the only case arising out of the Civil War that involved any sort of civil liberties that the Supreme Court decided was the Milligan case. But you get into and that wasn't a First Amendment case. But you get into World War I, and you get some of the first cases involving claims of First Amendment freedom as opposed to the, in opposition to an act of Congress. Wilson asked for more authority from Congress than he ever got. He asked for the authority to censor newspapers and magazines, but the House of Representatives refused to give him that. They did give him very broad authority, and the government generally broad authority in something called the Espionage Act. And one of the things that the Espionage Act prohibited was inducing, and I'm just paraphrasing here, inducing any person eligible for the draft to resist the draft. And a man named Schenck, who lived, I think, in Pennsylvania, Schenck sent out circulars to people who were being required to register for the draft, telling them the draft was illegal, unconstitutional, they should resist it. And He was convicted of violating that provision of the Espionage Act, and the Supreme Court, in an opinion by Justice Oliver Wendell Holmes, upheld his conviction, saying that if the letter was could be said to cause a clear and present danger of that sort of coming about of that as kind of evil that Congress has the authority to prevent, if free speech isn't a defense to it.
How would you characterize your own feelings about what kind of freedoms people should have during a wartime situation?
Well, I don't know if I can come up with a catalog of them. One thing you see is a trend from the Civil War to the World War I and World War II, a very ameliorative trend so far as First Amendment rights are concerned. In the Civil War, the Lincoln administration was just very ruthless about denying mailing privileges to newspapers that disagreed with the prosecution of the war. World War I, you had some of that with the Postmaster General Burleson denying mailing privileges to some magazines. By the time of World War II, you have virtually none of that. So it seems to me that that free speech, freedom of assembly, that sort of thing, are rights there's simply no reason to curtail in wartime.
Why do you think this changed over the number of wars we've had?
Because, partly because the presidents began going to Congress rather than just acting on their own. The Lincoln administration tended to act on its own. The Wilson administration tended to go to Congress, and the same was true with FDR in World War II. And also because there have been more and more court cases that have, you know, delimited the bounds of First Amendment freedom, but some of them have ruled against the government.
I think, if I wrote it down correctly, you said in your book that strong criticism of government policy must be permitted in wartime.
Yes, there was a new masses, not a new masses case, but one of the cases that came up right after the First World War, where the court as a whole upheld the conviction. And the people were basically just arguing that Wilson was now sending help to the White Russians, and we were no longer fighting the war we thought we were fighting, and that we would simply ought to stop that and have a general strike in order to insist on that. And the court as a whole upheld the conviction. But the Brandeis dissent said, which I think I agree with, that you have to allow debate about when the war aims have been achieved, or when things, as we witnessed in Vietnam. You can't just say that once war is declared, you can have no criticism of the war effort or no opinion saying it's time to have peace.
Is there a difference in this country when it's a declared war versus a conflict?
Oh, I think there's a considerable difference. There's a case called the Steel Seizure case, which I discussed in my first book, came up during the Korean War. It was when I was a law clerk to Justice Jackson. And it was not a time of declared war. And I've always had the feeling, and I think a lot of other people did, there the court ruled that President Truman did not have authority to seize the steel mills. I think if there had been a declared war, I think the case would have come out differently.
You mentioned your first book was The History of the Supreme Court. Give me the title of it, the Supreme Court, How It Was and How It Is.
Yes.
What do you think of this business of writing books?
Well, I enjoy it. It's very nice to be able to write something you don't have to get 4 other people to agree with you before it can become authoritative.
How do you do it? Where do you do it? And when do you do it?
A lot of it I do in the summertime, sometimes on weekends. You know, over a period of 14 years, I've written 3 books, so it's not as if I were turning out a book a year.
Which one of these 3 do you think in the end will have sold the most?
The Supreme Court books sold much better than the Grand Inquest book.
Why do you think?
Probably because the Supreme Court is a subject of more general interest, and perhaps the title Grand Inquest doesn't even tell you what it's about. So I think it's because of the subject.
Now, the Grand Inquest book, is that today available in paperback?
I think it's out of print, both hardback and paperback.
You used Knopf this time as your publisher. When you work with the publisher and you're the Chief Justice of the United States, do you work directly with an editor, or do they have to go through your staff, or how does that work?
Oh, no, I work directly with an editor. Lisa Drew at Morrow was my editor on the first two books, and Pat Haas has been my editor on this book.
Why did you switch publishers?
Lisa Drew left Morrow, and I don't know just where she went. I thought she was an excellent editor. And then Pat Haas is a friend of mine and friend of other people I know, and she talked with me about the possibility of doing a book for Knopf. And so I went to Knopf and signed up with them, and she was the editor.
Now, you said that you wrote a lot more than is in this book?
Well, I wrote, I wrote sentences that were 6 lines long, and they would be trimmed down to a sentence that was 3 lines long, but it was much improved.
On the back of the book, they have endorsements, and people of varying political persuasions say things like this. Doris Kearns Goodwin says about you, William Rehnquist is a national treasure. Were you surprised when you read that?
Well, I'm very flattered, naturally. I think she's a fine author. That book she wrote about Franklin and Eleanor, I thought was just a splendid book.
Doug Brinkley, who, and by the way, all 3 of these people have been on this show, so that's why I'll mention them. Doug Brinkley says, William Rehnquist, All the Laws But One, is a brilliant, gripping inquiry into how our American democracy functions. This is legal history at its very finest, written by a great Chief Justice, great Justice of the United States.
Well, naturally, I'm very, very happy with that sort of an accolade.
Now, you've been on this court for how long?
25 years.
How long have you been Chief Justice?
12 years. I'm in my 13th now.
And the last time we talked was 6 years ago.
Yes.
What has those 6 years been for you? Anything unusual? Anything different?
Just getting older.
How do you like that?
How do I like getting older?
Yeah,
Not very well.
Because one of the things you do mention in the book, and when you characterize a lot of members of the court, is you talk about age. And that Chief Justice Taney, you get the impression you thought he was too old to be on the court.
Well, he had been very ill during the last several years of his tenure. And in fact, the reason he stayed as long as he did was there was no retirement plan for the justices then, and he simply needed the income from being Chief Justice to live on. Now, that's all been cured today because we do have a retirement plan.
And the last time we talked, there were 4 former justices. They're all dead today. Justice Marshall, Justice Brennan, probably have to help me on this, Justice Powell, there was one other justice. How many retired justices are there now?
The Justice White and Justice Blackmun.
And what can a justice do when they're in retirement, and what kind of retirement do they get?
You mean what?
In other words, you say they can retire today, they get full pay to retire?
Yes. And they can sit on other courts, federal courts of appeals, for example. Justice Powell sat regularly on the 4th Circuit that meets in his hometown of Richmond up until 2 or 3 years ago. Justice White sits on the 10th Circuit, which sits in Denver, which is his home state, and I think he sat with the 9th Circuit out on the Pacific Coast because his daughter and her family live out there.
In the book, you mentioned Charles Warren's History of the Supreme Court, 3 volumes, and he was an assistant attorney general at one time for Woodrow Wilson. Have you read that?
Yes.
Is it good for a layperson to read? Is it the kind of thing that would help you understand the court?
It's 3 volumes long, and I think it's uneven. It's a little bit uneven. I think the first volume about Marshall is quite good. I don't think it's quite as good as it gets into the 2nd and 3rd volumes.
What is your philosophy about papers? I know that we've had a number of books written lately where, like for instance, Justice Marshall's papers became available from the Library of Congress. What would you do with your own papers?
Well, I think twice about giving them to the Library of Congress because I feel they really con Justice Marshall, and that I don't think he intended to have his papers released, although he certainly gave, I mean, I don't fault the library, he consented to it, but I think on second thought he probably would have done differently. So I haven't really decided what to do with my papers.
What's wrong with them releasing the papers?
Well, what's wrong with them is that you get notes of confidential deliberations in our conference. At our conference, We hear cases on Mondays, Tuesdays, and Wednesdays. And then Wednesday afternoon and Friday, we sit around a conference table adjacent to my office, just the 9 of us, no other people there at all, no staff, no secretaries, and talk about these cases. We discuss them and we vote on them. And those deliberations are always regarded as confidential because people like to let their hair down, and they can say something as absurd or that it's phony or something like that. There are things you wouldn't say to a public audience, but it makes for a much sharper discussion in conference. And so if you publish notes of deliberations that you've participated in, say, 3 years ago, it has a very unfortunate effect. People are going to say, well, gee, you know, if I know that 3 years from now what I say today is going to be published to the world, I'm not going to say quite the same things today.
Are you making any plans yourself? Do you have a diary? Do you keep notes? Do you keep, I mean, once you decide to let the world know what you were thinking privately during your time here, how are we going to read that? How are we going to see that?
Well, I don't keep a diary, and I trust that none of my colleagues keep diaries because I've always admired Robert E. Lee for his refusal to write his memoirs because, as I understand it, he said, to write my memoirs, I would have to deal critically and have to criticize people I work very closely with. And I feel the same way. I have no desire to write memoirs that give my exact opinion of everybody's position on a particular case. I mean, they are candid in conference, I'm candid in conference, and I think it should remain that way.
Go back to your book and talk about when people read this, there are lots of underlying themes in here, and one of them is the Supreme Court. You talk a lot about the justices.
Yes.
What do you rely on to get your information on what a justice was like?
There's a lot of judicial biography out. For instance, David Davis, whom I go into some detail with because he wrote the majority opinion in the Milligan case. There's a pretty good biography of him. I can't, it's in the bibliography. I can't think of the author's name right now, but a full volume biography just of David Davis. And the same is true of many other justices on the court. Harlan Stone, for example, who wrote the first opinion in the Japanese detention cases. There's a full volume biography of him by Alpheus Thomas Mason, who taught at Princeton.
But if somebody did a biography on you, where would they go? You're not anxious to talk a lot about things other than, you know, when we see you in the court. How would they know what you're like?
Well, I suppose talking to people who knew me, or maybe looking at a tape of this program, or reading my correspondence. I made my son my literary executor, and you know I expect him to make decisions about what to release and that sort of thing.
How many children do you have?
3.
And we talked about your daughter. Where's your son?
My son practices law in Boston.
And who's the other child?
My daughter Janet, who's a lawyer here she's an assistant U.S. attorney in Alexandria. All 3 of them are going to be at my book signing party tonight, which I think is very nice.
Now, you're not going to go on a book tour, are you?
No, no. I've been to a couple law schools that I'd undertaken to go to before. I went out to Drake in Des Moines in September. But I told my publisher that I was going to be in Des Moines, and so the publisher sent plenty of copies of the book, not just to the Des Moines bookstores, but to the Drake University bookstore. So I signed a number of books when I was there. Now I'm going up to Widener University this weekend, and I think I'll probably do the same thing up there. And I don't regard that as a book tour because I'm meeting with faculty, I'm giving a speech to the students and so forth. I regard it as more of a law school tour. But little things about the book do work their way in.
One of the reasons I ask you these questions is that since we last talked, one of the images people have of the court system is the O.J. Simpson trial.
Oh, Jesus. Well, strike.
I mean, what's the, I mean, if we can't see more of the members of the court here, and that's the image you have of the court system, does that worry you?
Yes, it does. I think if all one had to judge the court system by was the views they had of the O.J. Simpson trial, it would be a very unflattering view of the American judiciary and the American legal system and the American legal profession. Uh, how do you counteract it? Well, I suppose one possible answer is to say that you would have perhaps less celebrated trials, and they do have the court channel shows trials going on. They give you a much more normal impression of what's going on in the courts. Our court is fully covered by the press. It's not covered by television.
Are you concerned that I mean, have you looked at any surveys on what the attitude is of the court right now and the general public, this court?
I think I haven't looked at any recent one. It seems to me that the courts generally, and I don't know if they ask separately, but are generally pretty well respected in public opinion.
Go back to the World War II situation with the Japanese internment. Why did you write about that?
Well, because it was quite a big issue at the time, and has remained a big issue afterwards, because I think Congress voted to pay reparations in some cases, so that it's something that has not gone unnoticed even after World War II.
What happened? How did it happen?
Well, Pearl Harbor was bombed by the Japanese on December 7th, 1941, and the aircraft industries in the United States at that time were concentrated on the West Coast, primarily around Los Angeles and around Seattle. And there had also been emigration from Japan beginning around the turn of the century. That was pretty much confined to the coastal areas of the West Coast, so that there were two groups of Japanese there. The first were what were called the Issei, who were Japanese nationals who were not American citizens. And the second were called Nisei, who were Japanese children of these Japanese nationals, but born in the United States, and therefore under the 14th Amendment citizens of the United States. Well, after the attack on Pearl Harbor, which had been a sneak attack, there was great concern on the West Coast that the West Coast might be subject, not so much to invasion as to attack by aircraft carriers. My late wife grew up in San Diego, and she said, don't let anybody tell you that there wasn't a lot of fear on the West Coast at that time, because they had barrage balloons up in San Francisco. A Japanese sub was sighted off Santa Barbara. And so there was real fear that the Japanese had completely surprised the defenses of Hawaii, that they would also attack the West Coast. And so there was a movement. First of all, the Army created the Western Military, I think the Western Defense Command, something like that, and made it a separate military district because they thought it might have to be treated separately. But the urging for the detention of the Japanese came not first from the military at all, but from the civilians on the West Coast. Governor Culbert Olson, Attorney General Earl Warren, Mayor Fletcher Bowen of Los Angeles, and the congressional delegations in those states were very upfront about saying, you know, we need to take every precaution that we possibly can. We don't have time to find out whether any of these people individually are disloyal. We've got to simply intern all of them. And so ultimately the military adopted this view. There was there would first be a curfew, and then in the second stage, the Japanese located on the West Coast would be relocated in the interior at camps, very desolate camps with a lot of privation involved. And so it went back to Henry Stimson, who was Secretary of War, and John McCloy, who was Deputy Undersecretary of War, Assistant Secretary of War. And they said, we're going to have to get the approval of this from President Roosevelt. And the only person in the administration who really opposed it was the Justice Department. Francis Biddle was the Attorney General. And he fought against it, but finally it was just decided that they're going to have to go with it. So they asked for, Stimson asked for an appointment with Franklin Roosevelt, and Roosevelt said, I don't have time for an appointment, we'll just do it by phone. And so Stimson outlined the thing to him on the phone, and FDR said, fine, go ahead if it's necessary in the war effort to do it, we'll just go ahead and do it. So that's how that came about.
What do you think you would have done back then if you'd have been in a leadership position?
Oh, I think one of the most difficult things in the world to do is to second guess people who were in leadership positions at that time. You know, it's very easy in the atmosphere of the late 1990s to say something was a very bad thing to have done. That doesn't mean that it was not a very bad thing to have done. But so far as criticizing people who were in leadership positions at that time, you've got to realize they operated under the ethos and the standards of the times in which they lived. You know, maybe 50 years from now, we will all be damned because we're eating animal meat. And yet, on the standards we live on, it's perfectly all right to eat animal meat.
As a result of the Japanese internment, how much of this got to the court?
It came to the court in 3 stages. The first was the, I can't remember where the first was, I think the first was the Korematsu case. And that was a case where the court, by construing things very narrowly, had to decide only the question of the curfew, where Japanese Americans had to report for curfew at a certain time of night. They couldn't go out beyond that. And the court upheld that in a unanimous opinion by Chief Justice Stone. And then that was 43. Then 44, the Korematsu case came to the court. And that was where the Japanese had actually been removed from their homes. And I should add, there was also some very unhappy support for the Japanese, you know, people who wanted to buy their property once they left at a bargain, which was a terribly unmeritorious thing. But at any rate, the court upheld the relocation provisions. There were 3 dissents this time, so it held upheld the relocations by a vote of 6-3. And then in a case called the Endo case, which came down right after the Korematsu case, the court said that under the executive order that FDR had issued and had been confirmed by Congress, it seemed clear that if someone who was sent to one of these detention camps could prove their loyalty, that they should be released. And so that case came down in the end of 1944. The war was now going favorably for the United States. VJ Day would be May of 1945, VE Day, VJ Day, August 1945, and the program was just never reinstituted. So that's how it ended.
You wrote this near the end of the book. You said, thus distinctions that might be permissible between classes of citizens must be viewed otherwise when drawn between classes of aliens.
I think it's just the opposite. Decisions which would be impermissible.
Thus distinctions that might not be permissible.
Oh, not be permissible.
Between classes of citizens must be viewed otherwise when drawn between classes of aliens. What's that mean?
Well, that means that my evaluation of this in the present day is that under present-day constitutional law, you should not have been able to simply take Japanese Americans who are American citizens and classify, without making any effort to determine whether they were individually disloyal, simply remove them from West Coast aircraft factory areas. But I came to a different conclusion with respect to the Japanese nationals who are not American citizens, because there the law has always been clear that when you're dealing with enemy aliens in time of war, that this is a class of people that the government virtually has unlimited authority over. And of necessity, an enemy alien is someone who is, you know, by definition, presumably loyal to someone that you're fighting on the battlefield.
In the book, you also discuss the different sizes the court's been over the years, all the way from 6 up to 10. And you discuss in our last interview that John Marshall was your favorite, either Chief Justice or Justice. You worked for Robert Jackson as a clerk. The longer you stay on the court, do you find yourself being like other justices?
Well, it's hard to know. I don't think I ask myself that question. Perhaps, you know, a biographer might say, yeah, he was just like A, B, and C. But I don't ask myself that question, so it's a question I don't have any answer to.
Or do you find yourself with different opinions that have been written over the years that you say, oh yeah, I agree with that? Does somebody come up more often than not that after 25 years in the court?
Well, some of my predecessors.
Some of your predecessors, yeah.
I think they probably do, yes. Partly for writing ability. For instance, Justice Holmes' opinions are very, very pithy. They often are not quite as satisfying as they are pithy because he often tried to condense too much, I think. But they're very refreshing to read. And there's certainly other people. I mean, Justice Black was a very forceful writer. Justice Jackson was basically, not basically, but very much of an essayist. I mean, he could, you know, pick out a certain aspect of a case to treat and really make a mark that way.
When we see your name on the opinion as the, you know, if it's the majority opinion, your name's up there, you wrote it. How much of that did you actually write?
I will generally, if I assign myself a case coming out of the conference, previous to conference and oral argument, I will have worked on it with one law clerk. And I will sit down with that law clerk and tell him that, you know, I've assigned this to us to write, and go over the conference discussion with the law clerk. Tell him what each justice said in what seems to be the majority view, perhaps, you know, A, B, C, 1, 2, 3. And then tell the law clerk to put together a draft embodying that line of reasoning. And then the law clerk will put together the procedural background of the case and give me a rough draft of the line of reasoning that I've talked to him about. And I will then take that and revise it, often substantially shorten it. Because, you know, if you're drafting for somebody, the rule is, you know, when in doubt, include. But if you're someone who something's been drafted for, and you see this is unnecessary or unduly long, you feel perfectly free, obviously, to take it out. And if I don't think the points are made as clearly as they ought to be, I will revise that. So then I'll give it back to the law clerk. The law clerk may want to look at it again, and then we'll circulate it to the conference. So some opinions, I would say that my original contributions to them are definitely a minor part of them. Other opinions, my original contributions are a major part of them.
Do you have something that you always do in one of your opinions, something that you know, that it's your own, it's on a list of things that if it's a Rehnquist opinion, it's going to be in there?
You mean like a particular sentence or something?
Yeah,
like that?
or like a particular thing that you always want to cover. I mean, if people were, over the years have analyzed your work, is there something they would find all the time?
I don't think so. You don't mean a hidden sign or something on the page?
No, I don't mean that at all. I mean, you know, sometimes people have a technique that they use when they write or when they speak, and they always want to get a certain point across.
No, I don't think that's true of me.
We talked a little bit the last time about the number of cases that you try in the court here, and that number, as you know,
actually here. You try a case in a trial court where you put on evidence.
But your numbers have gone down into, what, as low as 80, 75 cases. And when you started here, there were, what, 150 cases a year?
Yes.
What's the philosophy of fewer cases?
I don't know that there is a philosophy of fewer cases. The numbers have simply gone down. I don't think any of us are really sure why. All we know is it's a fact.
So then when cases, I mean, the numbers of, how many are brought to the court, a number of cases that people want to be heard here?
Thousands. You know, I think last year the count was somewhere around 7,000.
And what's that like back when you researched the Tawney Court or the Marshall Court or any of the Stone Court or any of these other courts? How many cases would they hear in those days?
It was a different world back then, Brian, because now we have the discretion to turn down cases, which was granted as first in 1891 and then in a much larger measure in 1924. In the days of the Tawney Court, every person who lost in the highest court of a state or lost in a lower federal court had a right to take his case to the Supreme Court and get a decision on the merits. So that if they might have had only 400 cases a year, but that would be, although many fewer than our petitions, many more than the cases we decide on the merits. Because we decide, as you point out, less than 100 on the merits, so we take maybe 2% of the cases that people ask us to take. The Tawney Court had to take every case that people asked them to take.
Do you like the pace right now of the court?
Yes, I think it probably enables us to do a better job on the opinions that we do write.
What room are we in here?
The lawyer's lounge.
What's this used for?
It's used for meetings like this. We have 2 conference rooms, and I think last time when you interviewed me, we did it in one of the conference
East
rooms.
conference room, yeah.
And the lawyer's lounge is really a third, kind of a small conference room. The justices frequently meet with groups that come to see the court, and they want to hear one of the justices explain how the court operates and that sort of thing. And so we use this room and the 2 conference rooms for larger groups. And sometimes we have visiting judges from overseas come, and we'll meet with them in a place like this.
We're surrounded on the wall by justices. You have over here Justice Joseph McKenna.
Yes.
And over your left shoulder is Daniel Webster, who was not a justice,
No.
but a senator. And then there are 2 other, and I wrote them down before we started here. The other justice over your right shoulder is Justice, I think, William Strong, and then Justice Henry Baldwin behind me. The reason I brought that up, I wanted to ask you, is does every justice have a portrait in the court?
Yes. When I came to the court, there were several that didn't have portraits, but the Supreme Court Historical Society has been quite good, I think, about making up those vacancies. So there is a portrait now for every one of the, I think it's 106. Maybe it's more than that now. It's 100+ people who've been members of the court.
Based on what you wrote about in your book and all these different cases that had to do with the war and study of the court, if you could pick another time where you could go back and be on that bench and be among that group, what would it be?
Well, I think it would have been great to be in John Marshall's position, because you know, if you can say of the Supreme Court about with respect to anyone that it's the lengthened shadow of an individual, he is the lengthened shadow. When he came to the court, the power of judicial review, of declaring an act of Congress unconstitutional, had not been established. The court functioned very much like a highest court in England, the House of Lords, which has no power to declare an act of Parliament unconstitutional. All you decide is who finally wins in a lawsuit. And Marshall changed that and made the Supreme Court and the federal judiciary really a very participating third branch of the government, just like the Constitution said it should be. And so he stands head and shoulders above everybody else in terms of what he did for the present-day federal judiciary.
Another thing you write about in the book is justices involved in the political process. And you even talk about some justices that actively campaigned after they got on the court for president. Can you remember any of that?
I remember Samuel Chase, I think in the impeachment book, who stumped for John Adams in the election of 1800. I don't remember any others.
There was a Justice John Catron who continued to dabble in politics, you say, during the President Buchanan.
Catron was awful in one respect, and that is when the Dred Scott case was coming before the Supreme Court in 1857, and Buchanan had just been elected president, and the majority of the court had heard arguments in the case, but it decided to decide it on a narrow ground, and then the dissent said we're going to dissent on a broad ground, and the majority wanted to get as many people aboard as possible. And so the Catron asked Buchanan if he would prevail on a Pennsylvania justice, whose name escapes me at the moment, to see if he wouldn't line up with the majority, because he'd been unwilling to do that. And apparently Buchanan did talk to him, and apparently he changed his mind. which is just a terrible thing for Catherine to have done, and a terrible thing for Buchanan to have done.
In a couple of books since we've last talked, one of them was by Deke Deloche, wrote about J. Edgar Hoover. He served him in the Justice Department. You might have, did you know him?
I met him. I wouldn't say I knew him.
And in another book, we're talking about Abe Fortas's involvement when he was on the court with the Johnson administration. I guess it's just kind of a question to you. And Deke Deloche said, I think that, remember him saying he came up here to the court on some kind of a wiretap case and visited with the justice or the Chief Justice. What if somebody came to you right now, because you write about what's the right thing for the court to do, and said they're here representing the administration, they want to talk to you about a case?
You know, if, for instance, it were the Solicitor General or the Attorney General, someone who knew the practices of the court, I think I would certainly see them. Now, I might send them away in the first 5 minutes, but to say, you know, no, I won't hear a word you say. I think, I forget who it was that went up to the court for John Mitchell. Maybe it was John Mitchell himself, went to see Earl Warren about the Fortas situation. And yeah, I gather Earl Warren didn't turn him away. And you know, I think in some very extraordinary situation like that, it's perfectly permissible. But if the Attorney General's here to see you about a case, you know, you just turn him away right then.
What if the President of the United States, and I mean any President of the United States, calls you up and said, come down, I need to talk to you and I need some advice? What would you do?
Oh, I'd ask him what he needed advice about.
But what can you do as the Chief Justice of the United States? How far can you get involved?
Well, I would think virtually not at all. But again, you know, circumstances alter cases. I wouldn't want to give a categorical answer to that without knowing exactly what was being presented.
Let me wrap this up by asking you to talk a little bit about what you write about on Abraham Lincoln again. You go into great detail on the assassination. Why did you decide to do that?
Because I think it's so vivid. You know, a lot of things in legal history tend to be fairly dull. You know, the facts aren't all that interesting and that sort of thing. But Lincoln's assassination is just a very vivid thing. And, you know, there's been a book written, you know, The Day Lincoln Was Shot. I can't think of the fellow who wrote it.
Is that Jim Bishop?
That's Jim Bishop, yes. And there's been so much writing about it and happening at Ford's Theater and all these strange goings-on and this kind of conspiracy. And, you know, Mary Surratt is hung as a result of it. It's just a very fascinating chapter, perhaps less significant than some of the other ones for the long-term legal significance. But I thought just a very interesting bit of American legal history.
Have you ever gone back and done the trail around here, the John Wilkes Booth Trail, to see where he went and over here in Maryland?
I've driven over part of it, yes. I think Surrattsville is now Clinton.
And you say in here that Mary Surratt, and who was she?
She was kept a boarding house where some of the people who ultimately ended up assassinating Lincoln would meet.
And she was the first woman in the history of the United States to be hung?
Yes.
Why did they hang her?
Well, they hung her because she was convicted by a court-martial of complicity in Lincoln's assassination. And as I say in there, several members of the court-martial refused to sign the judgment until they had attached to it a plea for clemency to the president. And then a great dispute arose between President Andrew Johnson and Joseph Holt, who was the I can't remember exactly what position, but he was the one who was the Judge Advocate General, over whether Holt had ever shown that to Johnson, and that created a controversy between them for many years.
Now, how did it work once they caught all the people involved in the assassination? I mean, were they tried? Where were they tried?
A court-martial. David Hunter was the commanding general, and there were probably 8 or 10 other officers on the court.
And what was the reason that they were tried there instead of in a civilian court?
Because again, Stanton, who was the one who had the Indianapolis treason trials tried before him, thought that there was a danger of the South still wasn't quite defeated, and a danger of some sort of rebellion, or, you know, who knows who these assassins are after next. They tried to kill Seward, they killed Lincoln, and let's not fool around with the civilian courts.
Going to write another book?
I'll cross that bridge when I get an idea.
You don't have an idea this time?
No, well, I've never had ideas at the end of one book. I've never had an idea for another book. They just kind of crop up.
Any idea how many hours it took to write this?
No. No, I don't.
When did you finish it?
I thought I had finished it maybe last spring, but Knopf has very vigilant editors, and they always want one more round of editing. So I think I ended up finishing it late last spring.
When you wrote it, who did you envision reading it? Who do you hope, and what do you want them to get out of it?
Kind of the intelligent lay people and interested people in the legal profession, and just kind of get out of it that when you're dealing with civil liberties in time of war, you're not dealing with, you know, straight rectangles or straight lines necessarily. There's fuzziness involved, and there always will be.
I have one last question for you. It's an obligatory question. I'm going to read what you said last time when I asked you 6 years ago. We're about out of time. Do you like this job? You said, yes, I do. Then you said, I wouldn't want to hold it forever, but I've enjoyed it a great deal during the time I've had it. 6 years later.
Same answer.
Same answer?
Same answer.
No thought of retirement.
Well, you know, if I were thinking of retirement, I don't think you'd be the first person I'd tell about it.
Why not? When you see all the speculation in the press, and every year they write, you know, you haven't hired your clerks yet, so you're going to retire. What's your reaction to that?
Oh, let them talk.
On that note, here's the book. Our guest has been the Chief Justice of the United States. All the Laws But One, Civil Liberties in Wartime. Thank you, Mr. Chief Justice.
Thank you, Brian.
All the Laws But One is one of several books by Chief Justice William Rehnquist, including 2 books about how the Supreme Court works and the judicial nomination process, and grand inquests about impeachments. His most recent book, All the Laws But One, is published by Alfred Knopf, a division of Random House. You can find their website at www.randomhouse.com. We'll show our entire interview with the Chief Justice again at 1:30 a.m. Eastern. You can also find the interview on our website,